This is part 8, and we shall continue our discussion to deal with section 9 of the Negotiable Instrument Act, which defines holder in due course. Holder in due course is a kind of a holder, and once a holder becomes a holder in due course, naturally he shall be having some rights and privileges which are not at all exercised by a holder. Now, we have started discussing with the same, and then we have learned that holder in due course means any person who for consideration. So the first requirement is that he must give consideration, or he must become the possessor of a promissory note, bill of exchange, or check if payable to bearer, or payee or endorsee thereof if payable to order. That is one thing. And hence, when he becomes possessor of promissory note, bill of exchange, and check, the negotiable instrument that he has received or of which he has become possessor must be complete and regular. When we say complete and regular, it's not only on the face of it, but back of the negotiable instrument. And the back of the, as far as the importance of the back of the negotiable instrument is concerned, with which we shall be dealing when we start with the negotiation, and especially when I will discuss endorsement. When the instrument is what is known as an order instrument, there is required to be an endorsement and delivery of the negotiable instrument. So it must fulfill all requirement if it is promissory note is concerned as far as section 4 is concerned, if it is bill of exchange section 5 is concerned, and if it is check as far as section 6 is concerned. With this now, he must get that instrument or receive that instrument before, as it is said, before the amount mentioned in it became payable. In other words, to simplify it, he can become holder in due course provided he has received the negotiable instrument before maturity. And for the purpose of understanding maturity during course of time, if you remember, we dealt with section 19, yes, we dealt with section 21, section 22, section 23, section 24 and section 25 of the Negotiable Instrument Act. Now, when we were discussing section, especially section 21, there we learned, in a promissory note or bill of exchange, the expression at sight and on presentment means on demand. So if a promissory note or bill of exchange is payable on demand, unless there is a demand, you cannot say that it becomes mature. And then it can remain into circulation for n number of years, because the maturity will be decided when there is a demand, otherwise not. Now, we will come to this aspect at the time of discussing the procedure. But what happens if there is a demand after n number of years, and if the maker doesn't carry out the payment, or if it is accepted by the drawee who has become what is known as an acceptor, and if it doesn't carry out the payment, what is the remedy that is available to the holder? And naturally, holder will have to resort to the remedy of going to the court of law to file a suit. And when he files a suit, the procedure is nowhere mentioned as far as the Negotiable Instrument Act is concerned, for which you will have to read the provisions of the Civil Procedure Code. And when you start reading Civil Procedure Code, you will have to read right from section 1 up to section 158 of the Civil Procedure Code is concerned. And then when you refer to the schedule, you will have to refer to right from order 1 up to order 51, which consists of, each order consists of various rules. So that should be the approach from the point of view of learning Civil Procedure Code, with which you shall be dealing during course of time, no doubt about it. But then, along with this now, when the matter goes to the court of law, the court is guided by one more enactment, namely the Indian Evidence Act. And there can be a provision where you will have to, resort to specific relief act. For the purpose of going to the court of law, you are governed as far as the Court Fees Act is concerned. What is the amount of the fees that is required to be paid when you go to the court of law? There is a clear-cut distinction between general stamp and court fees, yes, with which you shall be dealing. And then it is not that you can take matter as per your sweet will to the court of law. The important enactment, the basis of which is law helps diligence and not indolence, is the Limitation Act of 1963. The object of the Limitation Act is not to extinguish the right but to bar the remedy. If you go to the court of law after the period that is stated as far as limitation is concerned, naturally your suit is not maintainable by the court of law, and hence now this is the time for me to draw your attention that when we deal with the provisions as far as Negotiable Instrument Act is concerned, and when you refer to the schedule as far as the Limitation Act of 1963 is concerned, and start reading right from Article 31 up to Article 41, these are the articles which deal with or tell you the period. There are 3 vertical columns, yes, and then the last vertical column makes mention when the period begins to run. So when you read these articles at the time of filing a suit which is based on the negotiable instrument, you will come to know what is the period of limitation. If you read Article 32, if you read Article 35, as far as the as far as the first schedule, when you deal with the Limitation Act of 1963, you will come to know that yes, in case of when the instrument, namely promissory note or bill of exchange, is payable on demand, in all the cases the period of limitation is 3 years, and hence now details you can work out, no doubt about it. Hence, though we say that it is Negotiable Instrument Act is general enactment, but then Indian Limitation Act with which you shall be dealing, you are guided by, as far as the filing of a suit in a court of law is concerned, guided by that. And hence in case of a promissory note, general practice that has been followed, when if it is payable on demand or if it is payable, bill of exchange is payable on demand, then before this period of 3 years gets exhausted, everywhere there is a demand for the purpose of renewal of the note or bill of exchange, so that you can go to the court of law in case you are compelled by the circumstances to file a suit in a court of law to establish your right. That is the practice that has been followed, and hence that is one point which I wanted to make mention as far as the filing of a suit is concerned, or when you talk about maturity when a negotiable instrument is payable on demand is concerned. With this now, the last part of section 9, and what is that? And without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. So this is the state of mind. In English law or some of the books, this state of the mind is described by the terminology, the holder, he can become a holder, in due course, provided he has acted in good faith. Now, whatever may be whether it is good faith or whether it is without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title, whatever it might be, mind well one thing, that there is a clear-cut distinction as far as the meaning of the term good faith when you deal with the provisions of the criminal law and when you deal with the provisions as far as the civil law is concerned. In case of criminal law, there is a test of what is known as objectivity. If you read section 52 as far as the Indian Penal Code is concerned, as far as criminal law, as far as the civil law is concerned, the test is not objectivity, but it is subjectivity. Namely, the court will take into consideration the state of the mind of an individual, and namely will take into consideration the state of the mind of the holder, whether he has whether he has acted honestly or not. If there was no suspicion at the time when he derived his title from the person, then naturally when court comes to the conclusion that he has acted honestly. Now here the question whether he was negligent or not, that shall not be taken into consideration by the court of law, because that is not the requirement of the section, that is the requirement of the next section with which we shall be dealing, namely payment in due course. Yes, but here it is not so. So if such a person, namely holder, without having sufficient cause to believe, though there is no doubt in his mind, there is no suspicion that he is to believe that any defect existed in the title, that is, I am getting it from a person whose title is defective, he must be a finder, he must be a thief, or his title must be defective, then not. But otherwise, and this is because his state of the mind, that there is always, so it is because of your state of the mind it is possible for you to become a holder in due course. Subject to, you have got it for consideration, you have got it before maturity, it is complete and regular, yes, these are must, no doubt about it. You can't, it's a law, and mind well, ignorance of law, when you say that it must be complete and regular, you can't say I was not knowing, because ignorance of law is no excuse. Yes, that is the principle you must remember forever. But as far as the last part is concerned, namely that whether he has acted in good faith or not, that is the term which is used, or this state of the mind, there also it is only subjective element that is required to be taken into consideration, and hence such a person becomes a holder in due course. Now if he becomes a holder in due course, naturally there are certain, I had drawn your attention, in the capacity of a holder in due course, if he goes to the court of law, then naturally the first thing which is in his favor, or because of which it's very easy for him to get justice in the court of law, is because of section 118, when you read small g. And what is that with which we are dealt in the past? That holder is a holder in due course, there is a presumption. And what it says, until the contrary is proved, the following presumption shall be made. So this is a presumption, that the holder of a negotiable instrument is a holder in due course. I had referred to it in the past. Consideration, that every negotiable instrument was made or drawn for consideration, and that every such instrument was, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. That is that is small a as far as section 118 is concerned. With this now, if you proceed to this chapter, namely chapter number 13, special rules of evidence, these are specially enacted because when you get a negotiable instrument, you are interested to claim amount or get amount for which the negotiable instrument is drawn, you never purchase litigation. And you never get negotiable, you never receive the negotiable instrument with this, that one day or the other you will have to go to, but then anything is possible, and hence if it is necessary for you to go to the court of law, going to the court of law is made easy as far as special rules of evidence are concerned. Section 120, estoppel against denying original validity of instrument. And what says? No maker of a promissory note, no drawer of a bill of exchange or check, and no acceptor of a bill of exchange, for the honor of the drawer shall, in a suit thereon by a holder in due course, so the suit is by holder in due course, be permitted to deny the validity of the instrument as originally made or dropped. Now, section 120, section 121 and 122 which deal with, the principle of estoppel or doctrine of estoppel. Those of you who are interested to know the details of the same can refer to the provisions of the Indian Evidence Act right from section 115 up to 117. And this is the principle. What is the principle? You are estopped. You are not allowed. You cannot raise a defense. You can't say so in a court of law. And that you will learn, in detail. But here, once, there is a suit on the part of the holder in due course, as per section 120, not permitted to deny the maker, no maker of a promissory note, and no drawer of a bill of exchange or check, and no acceptor of a bill of exchange for the honor of the drawer shall, in a suit thereon, by a holder in due course, be permitted to deny the validity of the instrument as originally made or drawn. Section 121, estoppel against denying capacity of payee to endorse. And it says, no maker of a promissory note and no acceptor of a bill of exchange payable to order shall, in a suit between by a holder in due course, be permitted to deny the payee's capacity at the rate of note or bill or endorse the same. So there, this is again a principle that is, this will help the person, for example, that this defense cannot be raised, this stand cannot be taken by the court of law, which is in the favor of the holder in due course. And section 122, estoppel against denying signature or capacity of prior party. And it says, no endorser of a negotiable instrument shall, in a suit thereon by a subsequent holder, be permitted to deny the signature or capacity to contract of any prior party to the instrument. Now the person who wants to recover the amount has got right to recover amount from any one of the prior parties. Yes. And hence now, these are the spatial rules of evidence, and this is the chapter that you have to understand from the point. And because of this, now there is always free circulation of the negotiable instruments, that you know that these are the sections which come to your rescue, as compared to, as in case, for example, ordinary civil suit, the burden of proof lies on a particular party who asserts a particular fact. But here he did not. Because of what? Because spatial rules of evidence, as far as chapter 13 of the Negotiable Instrument Act is concerned. As and when it is necessary, we will come back to this aspect, no doubt about it. But then, for the time being, this serves the purpose from the point of view of understanding. With this now, we shall be dealing with one spatial right of holder in due course, and that is with respect to inquired stamp instrument. And this is lengthy, but as you even though it is lengthy, what you are supposed to do? You are supposed to read, you are supposed to analyze, and hence I start now. It says, where one person, for example A, signs and delivers to another a paper stamps in accordance with the law relating to negotiable instrument then in force in India. So what he has done? He has signed a negotiable instrument, if it is a promissory note or bill of exchange, naturally on the stamp, or if it is a check, for example, then the question of stamp doesn't arise. And either wholly blank, or having written thereon an incomplete negotiable instrument. So he has not completed. Inchoate means incomplete. He might not have written date, he might not have written amount, he might not, the requirement he might not have completed. Only what he has done? He has signed. Yes, signature is must. and he has, if there is a at times if it is a promissory note or bill of exchange which is required to be properly stamped and stamp is required to be duly cancelled, he has done so. That is one thing. And now what he does when he has done so, he thereby gives prima facie authority to the holder thereof to make or complete as the case may be. So A has given such inchoate or incomplete instrument to Mr. B, then he gives Mr. B authority to complete the same. And then now for any amount, so we go back and understand, where one person signs and delivers to another a paper stamped in accordance with the law relating to negotiable instrument then force in India, and either wholly blank or having written thereon an incomplete negotiable instrument, he thereby gives prima facie authority to the holder thereof to make or complete as the case may be upon it a negotiable instrument for any amount specified therein, not exceeding the amount covered by the stamp. So now if it is in case of a promissory note or in case of a bill of exchange, what is the amount of the stamp that is required to be affixed, for which we have dealt with the Indian Stamp Act, and especially we refer to, as far as promissory note is concerned, Article 49 as far as first schedule is concerned, and Article 13 as far as the first schedule is concerned with respect to the bill of exchange, that is the amount. So he gives him authority that you can write down the amount which will be covered by this particular stamp. Now the person so signing shall be liable upon such instrument in the capacity in which he signed the same to any holder in due course. So the person B, what he has done, B was allowed to write amount of only 5,000 rupees, but the amount of the stamp covered 10,000 rupees. So what Mr. B has done, B, instead of writing down 5,000 rupees, he had completed. So no amount was written by Mr. A, it was merely signed, and then if at all stamp is required, he has affixed stamp that was and duly cancelled by him. Yes. So now if Mr. B has passed on that negotiable instrument, negotiation and rest of the details with which we will continue our discussion as far as the procedure aspect is concerned, but he had done so. So now here the further part says, the person so signing shall be liable thereon on such instrument in the capacity in which he signed the same to any holder in due course for such amount, provided that no person other than a holder in due course shall recover from the person delivering the instrument anything in excess of the amount intended by him to be paid therein. So if B wants to recover, B can recover only the amount for which he was authorized. But if C, if it is given to C to Mr. D and D to Mr. E, these are other, a holder in due course has got right to recover the amount. So that is as far as the inchoate stamp instruments are concerned, and what is the right of the holder as far as the inchoate stamp instrument is concerned is dealt as far as section 20 is concerned. With this now, there are some sections to which I am going to make mention now, but we can understand those sections during the course when we deal with detail as far as the procedural aspect is concerned. And that is one section to which I want to draw your attention is section 36, because we are going to deal with who are the parties as far as the negotiable instrument is concerned and what is their liability with which we shall be dealing. So section 36 says liability of prior parties to holder in due course, and it says every prior party. So this is, when you talk about liability of the prior parties, this is the right of the holder. And section 36 says every prior party to a negotiable instrument is liable thereon to a holder in due course until the instrument is duly satisfied. So this is the right of the holder. Holder in due course has got right to recover amount from any one of the prior parties, as made very clear as far as section 36 is concerned. section 42, acceptance of bill drawn in fictitious name. And it says, an acceptor of a bill of exchange drawn in fictitious name payable to the drawer's order is not, by reason that such name is fictitious, relieved from liability to any holder in due course, claiming under an endorsement by the same hand as the drawer's signature and purporting to be made by the drawer. So this is also right of the holder which is dealt as far as section 42 is concerned. As soon as we try to understand provision regarding acceptance, we will come back to this section 42. With this now, section 53 of the Negotiable Instrument Act also deals with what? Right of the holder in due course. And it says, holder deriving title from holder in due course. And what is it? It says, a holder of a negotiable instrument who derives title from a holder in due course has the rights thereon of that holder in due course. So he will be having the same rights as that of the holder in due course as far as section 53 is concerned. With this section, if you read section 58, it says, instrument obtained by unlawful means or for unlawful consideration. And then section 58 says, when a negotiable instrument has been lost, when it is lost, or has been obtained from any maker, acceptor or holder thereof by means of an offence or fraud, or for an unlawful consideration, no possessor or endorsee who claims through the person who found or so obtained the instrument is entitled to receive the amount due thereon from such maker, acceptor or holder, or from any party prior to such holder, unless such possessor or endorsee is, or some person through whom he claims was a holder thereof in due course. So that is again a right of the holder in due course as far as section 58 is concerned. With this now, one more section to which I want to draw your attention, and that is section 59. Now what happens if the instrument is acquired after maturity? And section 59 says, the holder of a negotiable instrument who has acquired it after dishonor, whether by non-acceptance or non-payment. Now this is, I have not dealt with it. We shall be dealing, no doubt about it. But for the time being, try to understand section 59 to be understood in the context of holder and a holder in due course. It says the holder of a negotiable instrument who has acquired it after dishonor, whether by non-acceptance or non-payment, with notice thereof or after maturity, has only, as against any other party, the right thereon of his transferor. So if he gets a negotiable instrument after, this is after maturity. I am not talking before maturity he becomes a holder in due course, and after maturity he becomes a holder. But what is his right? His right is that of the transferor as far as section 59 of the Negotiable Instrument Act is concerned. With this now this is a time for us to start with the Negotiable Instrument Act in the real sense of the term. Now we are dealt with section 19. So this is a time in the next lecture we shall be dealing with section 14, which deals with negotiation. And for the purpose of understanding negotiation as dealt by section 14, there, depending upon the nature of the instrument, it is also necessary for us to take into consideration parties with respect to negotiable instrument, for which we shall be dealing right from section 26 up to section 45A of the Negotiable Instrument Act. Then when you correlate negotiation, we have a chapter on negotiation right from section 46 onwards, with which we will continue our discussion. And then we will understand what is presentment right from section 61 up to section 76 of the Negotiable Instrument Act. And then we will deal with payment of interest when we will deal right from section 78 onwards as far as the Negotiable Instrument Act is concerned. And then when a discharge from liability of notes, bills and checks, for which we will take into consideration right from section 82 up to section 90. And the procedure as far as notice of dishonor is concerned, we shall be dealing right from section 91 up to 98. And then what do you mean by noting and protest, that shall be taken into consideration as far as right from section 99 up to section 104A. The concept of reasonable time, with which we shall be dealing as far as section 105, 106 and 107 is concerned. Then we will discuss the provisions regarding acceptance for honor, payment for honor, and rest of the details when we will deal right from section 100. So this is the sequence that we are going to follow. When I was a student, to understand a subject, my teacher used to tell in the class, when you come to the class, you read and come to the class. When you are in the class, be attentive in the class. And when you go back, again read the same. And then if at all you have got any difficulty, by all means you can ask any difficulty to me, for which I don't have any objection. I don't claim that I know everything as far as law is concerned, because law is such a vast subject that nobody can claim it. Yes, but then it's possible for me to read and try to satisfy you, or try to explain the difficulties that are raised by you. So you are at liberty. Now the ball is in your court. I will proceed in this particular manner for the purpose of dealing with the rest of the provisions as far as Negotiable Instrument Act is concerned, with which we will continue our discussion in the next part.